Hi, Public Law 11053, 1911 Commission Act of 2007, Sec 1408, Public Transportation Security Training Program. In general, not later than 90 days after the date. And 6 United States Code 1137, guideline regulations, and not later than 90 days after the date of the enactment of this act, the Secretary shall develop and issue detailed interim final regulations not later than 1 year after the date of the enactment of this act. The Secretary shall develop and issue detailed final regulations of public transportation security training program to prepare public transportation employees, including frontline employees, of potential security threats and conditions. B. Constellations. The Secretary shall develop the interim final regulations under subsection A in Constellation 1, appropriate law enforcement, fire services, security, terrorism, experts, representatives, public transportation agencies, and 3. Non-profit employee labor organizations representing public transportation employees or emergency response personnel. C. The program and elements, the interim final regulations developed under the subsection A shall require security training programs to include the minimum elements to address the following: 1. Determination of serious and occurrence of the threat, 2. Crew passenger communication coordination, 3. Appropriate response to defend oneself, including use of non-lethal defense devices, 4. Use of personnel protective devices, other protective equipment, 5. Evacuation procedures, passengers, employees, including individuals with disabilities and the elderly, 6. Training related behavioral psychological understanding of in response to terrorist incidents, including the ability to cope with a hijacker behavior and passengers' response, 7. A live situational training exercise regarding various threat conditions, including tunnel excavation procedures, 8. Recognition, reporting dangerous substances, suspicious packages, persons, and situations. 9. Understanding security incidents procedures, including procedures, communication, government and non-governmental emergency response providers for one scene interaction within the search emergency response providers. 10. The operation for maintenance of security equipment and systems. 11. Other security training activities security deems appropriate. Deadlines required. D. Required to programs development and submission to the Secretary not later than 90 days after the Public Transportation Agency meets the requirement under subsection E. Each of the following public transportation agencies shall develop a security training program and in accordance with regulation developed by under subsection A, submit a program to security for approval. 2. Approval for not later than 90 days after the receiving security training program from the personnel from the proposal of under the subsection of the Secretary shall approve from the program, requiring to the Public Transportation Agency that developed the program to make any revisions of the program the Secretary determines necessary to program to meet the requirement of the regulations of Public Transportation Agency shall respond to the Secretary comments within 30 days after receiving it. 3. The training no later than 1 year after the Secretary approves the security training program proposes in accordance with the subsection Public Transportation Agency developed. The program shall be complete with training. All employees are covered under the program. 4. Updates of regulation program revisions. The Secretary shall periodically review, update appropriate and train regulations issued subsection A to reflect the new change in security threats in each public Transportation Agency shall revise the training program according to the provided additional training necessary. It works as responsible time after regulations are updated and applicable ability. A publication Transportation Agency receives a grant award for under its title shall be required to develop, implement a security training program pursuant to this section. F. Long-term training equipment requirement. Any public transportation agency required to develop a security training program pursuant to this section that shall provide routine ongoing training of the employees covered under the program, regardless whether the public transportation agency receives subsequent grant awards, e.g. the National Training Program. The Secretary shall ensure the training program developed under subsection A is competent with national training programs established under section 648 of Coast Katrina Emergency Management Reform Act of Public Law 109-295, 6 United States Code 748. Ferry exceptions. The section shall not apply to any ferry system for which the training is required to be conducted pursuant to the section 70103 of Title 46 United States Code. I. The report no later than 2 years of the date of the issuance of final regulation of the Comptroller shall review the implementation training program, including the interviewing representative sample public training transportation agency employees or to the appropriate congressional committee as the number of reviews conducted as the result of the Comptroller General may submit the report in both classified redacted formats as necessary. Section 1409, the Public Transportation Research and Development Establishment and Research and Development Program. A secretary shall carry out the research development program through the Homeland Security Advanced Research Project agencies and the Science and Technology Directorate in consultation of the Transportation Security Administration with the Federal Transit Administration for the purpose of improving the Secretary of Public Transportation System. B. The grants contract authorized the Secretary shall award grants and contracts public-private entities to conduct the research, demonstrate technologies, methods to reduce and deter terrorist threats, mitigate damages resulting in terrorist attacks against the public transportation systems. Use of funds, grants, contract award under subsection A shall coordinate with activities of Homeland Security Advanced Research Project agencies. 2. May be used as research, chemical, biological, radiological, explosive detection systems that do not significantly impede passenger access. Research, imaging technology. C. Conducting product evaluation and testing. Improving security redundancy for the critical communication, electrical power, computer, and train control system. E. Developing technologies for securing tunnels, transit, and bridges, aerial structures. F. The research technology mitigate the damage of event of the cyber attack. And G. Research for technology method of reducing, deterring terrorist attacks against public transportation system, mitigation damages from sub attacks. D. The privacy and civil rights of civil liberty issues. 1. Consulting and carry out the research development projects. Under this section, the Secretary shall consult the Chief Privacy Officer of the Department, Officer of Civil Rights and Civil Liberties of the Department as appropriate and in accordance with Section 222 of the Homeland Security Act of 2002, 6 United States Code 142, Privacy Act, Privacy Impact Assessments in accordance with the Section 222, 705 of Homeland Security Act 2002, 6 United States Code 142, 345. The Chief Privacy Officer shall conduct privacy impact assessments of the Officer of Civil Rights and Civil Liberties shall conduct reviews appropriate for the research development initiatives developed under the sections. E. The reporting requirement for each entity awarded with the grant contract under the section shall report annually to the Department of the use of grant and contract funds received under the section to ensure the awards made are expended in accordance with the purpose of the title priorities developed under the Secretary. F. The coordination of the Secretary shall ensure the net research consistent with the priorities established in national strategic public transportation security in coordination with the extent practicable within federal, state, local, and tribal private sector public transportation, railroad, commuter, railroad, over-the-road busing research initiatives, leverage resources, avoid unnecessary duplicate efforts, return from misspent grants and contract funds. If the Secretary determines a grantee or a contractor used inappropriate for the grant contract funds received under the section for a purpose other than allowable use or specified under the subsection C, the grantee or contract shall return any amount as so used as the Treasury of the United States. H. The authorization of appropriations. The authorization appropriated for the Secretary to make these grants under the section is such sums necessary for the fiscal year of 2007, $25 million for the fiscal year of 2008, 2009, 2010, 2011, and 6 United States Code 1139, Section 1410, Information Sharing, Intelligence Sharing. As the Secretary shall ensure that the Department of Transportation receives appropriate, timely notification all credible terrorist threat attacks are against the public transportation assets of the United States and assets in the United States. B. Information Sharing Analysis Center authorization. The Secretary shall provide reasonable cost of Information Sharing Analysis Center and Public Transportation referred to in the subsection as ISA. C. Is an Information Sharing Analysis Center participation of the Secretary. Public Law 11053, August 3rd, 2007, 121, Stat 413. A. Shall require the Public Transportation Agency of the Secretary determines that to be a high-risk terrorist attack for the participation of the Information Sharing Analysis Center. Shall encourage the Public Transportation Agency to participate in the Information Sharing Analysis Center. Shall encourage the participation of nonprofit employee organizations representing the transportation employees and as appropriate D. Shall not charge a fee for participating in the Information Sharing Act Center. C. Report. The Comptroller General shall report not less than 3 years of the date of enactment of this act that appropriate congressional committees as the value efficiently of the Inter Sharing Act Center along with the other public transportation information programs ongoing on the department. The report shall include analysis under this faction of the public transportation agency's information sharing the value of each system provided to the users, benefits all centers of the program, coordination among the centers of the program, how each of the centers of the program contributes to the implementation, information sharing of the program, information sharing under the Section 1203 analysis is extension within the ISAC and its duplicative department information and sharing program authorization in general. The authorized to be appropriated as secretary to carry out these sections $600,000 for the fiscal year of 2008, $600,000 for the fiscal year of 2009, C $600,000 for the fiscal year of 2010. D. Each sum may be necessary for 2011 for the report required for subsection C, and the section has been submitted to the Congress. Availability funds such sums shall remain available unexplained. Section 1411 threat assessments not later than 1 year after the date of enactment of the act. The secretary shall complete a name based on security background check against the consolidated terrorist watch list, immigration status checks, and all public transportation frontline employees, similar to the threat assessment screening plan program requiring for facility employee in Longshore Commandment of the Coast Guard under the Coast Guard Notice of the U.S. Standard Coast Guard 2006 2418971 Federal Regulation of 25066 April 8, 2006. Section 1412 Reporting Requirements. Annual report to Congress. In general, no later than March 31st of each year, the Secretary shall submit a report containing information described in paragraph 2. The appropriate congressional committees. 2. The contents submitted under paragraph 1 shall be included. A. Description and implementation provisions of the title. B. The amounts funded appropriated to carry out the provisions that have not been expended or obligated. Stat 4 121 Stat 414 Public Law 11053 August 3rd 2007. The national strategy of the public transportation security required under the Section 1404. D. The estimated cost of implementation national strategy public transportation security, which shall break out of the aggregated total cost of the national capital operational secretary improvements for the fiscal year of 2008 and through 2018, and in each the state of transportation security in the United States shall include a detailing status security assessment provided progress being around the country developing prioritized security improvements necessary to make public transportation facilities passenger made more secure. Progress being made. Agency developing security plans. How those plans differ from security assessment and prioritized list of security improvements being compiled in the agency, as well as random sample of an equal or number of large small-scale projects currently underway. 3. The format. The Secretary shall submit a report and classify reacted performance. The Secretary determines these actions as appropriate and necessary. B. An annual report to the governments and annual reports to the governors. 1. In general, not later than March 31st of each year, the Secretary shall submit a report to the governor of each state which of the public transportation agency that has received a grant under the Act. The report submitted under the paragraph 1 shall specify the amount of the grant funds distributed to such public transportation agencies and the use of such grant funds. Section 6 United States Code 1142, Section 1413 Public Transportation Employee Protections. In general, public transportation agency, a contractor, subcontractor of the such agency, officers, employee of the such agency shall not discharge, dismote, suspend, reprimand, or any other discrimination against an employee if the discrimination is due to in whole, in part, the employee's lawful good, and if the action done perceived that the employer has been done or about to be done. The 1. The provided information directly causes the information provided otherwise directly assists the investigation regarding the conduct of an employee reasonable he believes constitute violation of federal law, rule, and regulation relating to public transportation security, safety, security, and fraud, waste of abuse, federal grants, other public funds intended into the public transportation safety and security. If information assistant with provided investigation, steaming, and provided information conducted in federal, state, local regulatory law enforcement under the Inspector General Act of 1978, 5 United States Code Apt, Public Law 95 through 452. B. That any member of Congress, Committee of Congress, of Government Accountability Officer, and of the person supervisor or authority over the employee, such as the person of the authority to investigate, discover, terminate, and misconduct, to refuse to violate, assist violation of federal law, regulation relating to public transportation safety and security, to file a complaint if directly causes to be brought proceeding related to enforcement of the section of the testifying the proceeding to cooperate, satisfy security, investigate security of transportation security, Homeland Security, National Transportation Safety Board, or furnish the information Secretary of Transportation Security of the Homeland Security, National Transportation Safety Board, any federal, state, or local regulatory law enforcement agency facts relating to any incident resulting in the injury, death, and individual damage of property occurring in connection with the public transportation, hazardous safety, security conditions of a public transportation agency, contractor, subcontractor of such agency, officers, and employees of such an agency shall not discharge, demote, suspend, reprimand any other discriminating against an employee for the reporting hazardous safety or security conditions. B. Refusing to work when confronted with a fair hazardous safety or security condition related to the performance of the employee duties and condition would describe paragraph 2 or exist, or refusing the authorized safety or security related equipment, track structures, employee responsibility, inspection, repair equipment, track structures when an employee believes the equipment, track structures, and hazardous safety and security conditions described in paragraph 2 of the submission subsection exists. To the refusal protected under paragraph 1b and c, if the a refusal is made with good faith and reasonable alternative refusal is available to employ reasonable individual circumstances, the confronting employee that would include the hazardous condition present in imminent danger and death, serious injury. The urgency situation does not allow sufficient eliminating danger without refusal. C. The employee possible notified publication transportation agency existing hazardous conditions intent not to perform further work or not to authorize hazardous equipment, track, and structures use of unconditioned, correct, and immediately equipment, track, and structures repaired properly or replaced. In subjection only, subjection B1 A shall apply for the security personnel, including transit police employed utilized in public transportation agency to protect riders' equipment, assessment, and facilities enforcement action is in C. I'm gonna pause. Resuming at 121 Stat 416 Public Law 11053 August 3rd 2007 Deadline 1 filing notification. Filing and notification. A person who believes or he or she has been discharged otherwise discriminated against by any person violation of subsection A or B may not be later than 180 days after the date of which the violation occurs. Files or other person has files on his or her behalf a complaint of Secretary of Labor alleging such discharge discrimination upon receipt of complaint filed under the paragraph. Secretary of Labor shall notify the writing the person named of the complaint and the person employer in filing the complaint allegations contained in the complaint and the substances evidence of supporting the complaint opportunities that will be afforded for such a person under paragraph 2. Deadlines and notifications. 2. Investigation primarily ordered in general not later than 60 days after the date of receipt of complaint filed under paragraph 1 after the affording the name and the complainant with an opportunity to submit the Security of Labor a written response to the complaint, opportunity to meet representative Security of Labor to represent statements or witnesses. Secretary of Labor shall conduct and investigate to determine whether there is a reasonable cause to believe the complaint has merit or notifying writing complaint that the person alleged have committed a violation of subsection A or B. Secretary of Labor's findings. The Secretary of Labor concludes that there is a reasonable cause for believing violation subsection A and B has occurred. The Secretary of Labor shall accompany the Secretary of Labor's finding preliminary order not providing relief prescribed for paragraph 3b and no later than 30 days after notification findings of the paragraph either person alleged to have been committed violation complaint of the objection finding preliminary order to other both request or hearing and other or require record the filing such objections should not operate to stay in reinstatement remedy contained with the preliminary order. Such hearings shall be conducted expeditiously. If a hearing is not requested in 30-day period, a preliminary order shall be deemed a final order and that is not subject for judicial review. B. Requirement for showing a complaint. The Secretary of Labor shall dismiss a complaint filed under the subsection shall not conduct investigation otherwise required under subparagraph A unless the complaint is a prima facie showing that any behavior described in subsection A and B was contributing factor unfavorably personnel action alleged in the complaint. 2. The showing an employer notwithstanding the finding in Secretary of Labor the complaint has been shown required under Clause 1. No investigation under the required paragraph A shall be conducted on an employee demonstration of clear and convincing evidence that the employer would have taken other than unfavorable personal action in absence of behavior. 3. The criteria of determination for the Secretary of Labor. The Secretary of Labor may determine that the violation of subsection A and B has occurred only if the complaint demonstrates that any behavior described in section A and B of the contributing factor unfavorable personnel action alleged in the complaint. 4. The prohibition of relief may not be ordered. The paragraph A, the employer demonstrates the clear and convincing evidence that the employer have been taken the same unfavorable personal action in the absence of behavior. 3. The final order and deadline issuance of settlement agreements no later than 120 days after the date of conclusion of all hearings under paragraph 2. Secretary of Labor shall issue the final order providing the relief of prescribed in paragraph deniable complaint at any time. Issuance of final order proceeding under subsections may be terminated on basis of a settlement agreement entered in the Secretary of Labor. A complaint that the person alleged had committed a violation be the remedy in response to the complaint filed under paragraph 1 of Secretary of Labor determines that the violation of subsection A and B under Secretary of Labor shall order the person who committed the violation to take affirmative action, abate the violation, and provide remedies described in subsection D. C. If the order is issued to subparagraph B, the Secretary of Labor of the requested complaint shall assess against the person against whom the order is issued in a sum equal to agreement in the amount of all costs expense, including attorney, expert, witness fees, and reasonable in court heard, determined Secretary of Labor and complainant or connection within bringing complaint upon the order issued previously compliance. The Secretary of Labor has been complained under paragraph 1 frivolous or brought in bad faith. Secretary of Labor may award the prevailing employer reasonable attorney fees for not exceeding $1,000. Review appeal to the Court of Appeals. Any person advisory affected to the aggrieved and ordered issue under paragraph 3 may obtain review of the order in the United States Court of Appeals, the circuit in which the violation with respect to which the order which is issued and alleged according to circuit in which the complaint resided in on the date of such violation. The petition review deadline must be filed no later than 60 days after the date of issuance of the final order of the Secretary of Labor. Review shall conform to Chapter 7 of Title 5 of the United States Code. The commencement of proceeding the subparagraph shall not, unless ordered by the court, operate to stay in order. B. The limitation of collateral attack and order of Secretary of Labor will with respect to which review could have been obtained from subparagraph A and shall not be subjected for judicial review of any criminal or other proceeding. Enforcement of order, Secretary of Labor, whether any person filed and comply with any order issued on paragraph 3, Secretary of Labor may be file a civil action of the United States District Court to district which in the violations found to enforce such orders and actions brought down the paragraph. The district courts shall in jurisdiction to grant the appropriate relief including but not limited to injunctive relief and compensatory damages. Enforcement to orders by parties. Commencement actions. A person who is on behalf of order the issued under paragraph 3 may commence the civil action against the person to whom who was issued in compliance with such order. Appropriate United States District Court shall have jurisdiction without the regard of the amount of controversy, citizenship of the parties, and to enforce such order. Attorney fees. The court of the issuing and final order of the paragraph may award the litigation, including the responsible attorney expertise, witness fees, to any party, whether the court determines such awarded as appropriate. De novo review. The respective complaint under the paragraph 1 Secretary of Labor has been issued a decision 2010 days after filing the complaint. If the delay is not due to the bad faith of the employee may bring the original action to the law of equity. De novo review. Applicable district of the United States shall have jurisdiction over the action within the regard of amount of controversy which the action shall request either the party to such action to be tried by a court within a jury. The action shall be governed in the same legal burdens of proof specified paragraph 2b for review of Secretary of Labor. 1. The remedies. In general, the employee prevailing in the action under subsection C shall entitle to all relief necessary to make sure the employee whole. 2. The damages relief under the action subsection C, including the action described in C7, shall include reinstatement within the same seniority status of the employee who had have had the discrimination. B, any payback with interest. C, compensatory damages, including compensational and any special damages sustained as a result in discrimination, including litigation costs, expert witness fees, and responsible attorney fees. Public Law 11053, August 3rd, 2007, 121, Stat 419, possible relief or relief in action under subsection C, including punitive damages in an amount of not to exceed $2,500,000. Election of remedies, an employee may not seek protection under the both section on the provisional laws of same alleged unlawful public transportation agency. No preemption, nothing in sections of preemption diminishes and other safeguard is a discrimination, demotion, to discharge, suspension, threats, harassment, reprimanded, retaliation, or any other manner of discrimination provided in federal or state law. Rights and retained an employee. Nothing in this section shall be construed and diminish rights, privileges, remedies of all employers under federal, state law, under any collective bargaining agreement. The rights, remedies in this section may not be waived by any agreement, policy, form, or condition of employment. The disclosure and identity and except for provided in paragraph 2 of the subsection written consent of the employee, the Secretary of Transportation and Secretary of Homeland Security may not disclose the name of employee who has provided information described in subsection A. The Secretary of Transportation and Secretary of Homeland Security shall disclose the Attorney General name of the employee described in paragraph 1 of the subsection if the matter is referred to as Attorney General for the enforcement of the Secretary making sure such disclosure of such notification provider responsibility advance notification affected employee of the disclosure personnel identifying information is it to occur process reporting security problems of Department of Homeland Security establishment of the process the Secretary shall establish through regulations after the opportunity of notice of commitment provided to implement information public regarding the process which any person may submit a report to the Secretary regarding public transportation security programs deficiency vulnerabilities. These regulations notice public information and acknowledge the receipt. If the report is submitted under paragraph 1 identifies the person making the report, the Secretary shall respond promptly to such person acknowledge the receipt of the report. Steps to address the problem, the Secretary shall review, consider information provided any report submitted under paragraph 1 and shall take appropriate steps to address the problems and deficiency identified. Section 414, the Secretary, 1414, Section 1414, Secretary background checks covered individual public transportation. In the section following definition, Secretary background check, the term Secretary background check means reviewing following purpose of identifying individuals who may pose a threat in transportation security, national security, terrorism, relevant criminal history databases. B, in the case of an alien as identified in Section 105 of the Immigration and Nationality Act 8, United States Code 1101. A3, the relevant database to determine the status of an alien under the immigration laws of the United States. C, other relevant information database determined the Secretary. Covered individual, the term covered individual means the employee of the public transportation agency, contractor, subcontractor, public transportation agency. C, B, the guidance, any guidance, recommendations, suggested action items under the disseminated voluntary action items issued for the Secretary of Public Transportation Agency, contractors, subcontractors, public transportation agency performing a security background check. Covered individuals should contain recommendations on an appropriate scope of application such as security background check, including time period, covered types of disqualification offenses of a redress process advisory impact covered individual consistent with subsection CD and the sections. Deadline 2 no later than 60 days after the date of enactment of this act and any guidance or recommendations suggested action items that otherwise disseminated voluntary action and is issued in the Secretary prior to the date of enactment act of the Public Transportation Agency contract, subcontract, public transportation agency reform relating to the performance security background check covered individual showing the updated compliance with paragraph B1. 3. If the public transportation agency contractor or subcontractor of public transportation agency performs security background check on a covered individual, fulfill the guidance issued Secretary under paragraph 1 and 2, the Secretary shall not consider guidance fulfilled unless an adequate redress process is prescribed in subsection D provided to cover to the individuals. C. The requirements of the Secretary issues regulations directive requiring public transportation agency contractor, subcontractor, public transportation agency perform a security background check covered individual that the Secretary shall prohibit public transportation agency contractor, subcontractor, public transportation agency making an advisory employment decision including removable suspension employee due to such regulation, directive, and respect of covered individuals unless public transportation agency, contractor, subcontractor, public transportation agency determines the covered individual, one, convicted of found not guilty, reasonable insanity, or is under warrant indictment for impermanent disqualification criminal offense listed in paragraph 1572 of Title 49 Code of Federal Regulations, was convicted or found not guilty by reason of insanity in an interim disqualification criminal offense listed in 1572 Title 49 Code of Federal Regulations within 7 years of the date of public transportation agency or contractor of subcontractor of public transportation agency performed a security background check, or 3 was incarcerated for an interim disqualification criminal offense listed in 1572 Title 49 Code of Federal Regulations, released incarceration of 5 years date after date of the public transportation agency contractor subcontractor public transportation agency performed security background check, readdress process security issues, rules, regulations, directive requiring public transportation agency, contractor, subcontractor, public transportation agency to perform security background check of covered individual security shall, 1, provide adequate process covered individual subjected to advisory employment decision, including removal, suspension, employee due to such rule, regulation, directive consistent with the appeals waiver process, establish application, commercial motor vehicle hazardous material endorsement, transportation workers report required in section 701.405 C Title 49 United States Code, and 2, authorizing to order an appropriate remedy, including the reinstatement to covered individuals should secretarially determine the public transportation agency subcontractor, public transportation agency wrongfully made for the advisory employment decision regarding the covered individual pursuant to such regulation, direction, or directive. False statement of public transportation agency or contractor, subcontractor, public transportation agency may not knowingly misrepresent an employee or other relevant person, including the arbitrator involved with the labor arbitration. There's a scope of application, meaning that any rules, regulations, directives of the guidance secretary related to security background check requirements covered individuals when conducting security background check no later than 1 year after the date of enactment of this act. The security shall issue a regulation that prohibits the public transportation agency or contract subcontractor or public transportation agency knowingly misrepresenting to an employee of other relevant person, including any arbitrator involved in labor arbitration. That scope and application, meanings of rules, regulations, directives, guidance issues, related security background check requirements for covered individuals conducting security background check. The rights and responsibilities. Nothing in this section construed and abridged in public transportation agency, contractor, subcontractor, transportation agency rights and responsibility to make an advisory employment decision prohibited in federal, state, local, and laws. Nothing in subsection construed and abridged rights and responsibilities of covered individual public transportation agency, contractor, and subcontractor public transportation agency under the federal, state, local, and laws. Collective bargaining agreement. No preemption, federal, state, or law. Nothing in this section construed in preemptions, federal, state, local, and requires criminal history and background checks. Immigration status checks and background checks of covered individuals. 8. Statutory construction. Nothing in this section shall be construed to affect the process of review established under section 105C Title 46 United States Code, including regulations issued and pursuant to such section. 6. United States Code 1144, section 1415, limitation of fines, civil penalties. Inspector services and transportation inspectors shall be prohibited in issuing fines, public transportation agency violations, department regulations, orders, except through process described in subsection B. Civil penalties. The secretary shall prohibit the assessing civil penalties against public transportation agencies violations, department regulations, orders, except for accordance with the following notice. 1. In case of the public transportation agency that the found violation, regulation, order, and is issued, secretary shall seek the correction of the violation. Written notice. The public transportation agency shall give the public transportation agency responsible opportunity to correct the violation purpose of alternative means of compliance acceptable. Secretary, if the public transportation agency does not correct the violation purpose of alternative means of compliance acceptable, secretary reasonable time period this is specified by written notice, secretary may take any action to the section 11.14.49 United States Code as amended in this act. C. The limitations of the secretary. The secretary shall not initiate civil enforcement of violation of administrative procedural requirements pertaining to the application of expeditionary funds under award under the Transportation Security Grant Program under this title. Title 15, Surface Transportation Security, Subtitle A, General Provisions.